Welcome to the Copeland Coaching Podcast, where it's all about turning your job search into a slam dunk. Your host is Angela Copeland.
Welcome to the Copeland Coaching Podcast. I'm your host, Angela Copeland. Live in the studio with me today, I have Chip Cavagnaro in Memphis, Tennessee. Chip is an employment lawyer at Evans Petree. He represents clients in state and federal courts in all aspects of labor and employment law. He was selected by his peers for inclusion in the Best Lawyers in America 2017 in the area of labor and employment litigation for the second year. Chip's also a member of the Society of Human Resources Management and the Labor and Employment Law section of the Memphis Bar Association. Chip, thanks for joining me today.
Well, thank you for having me. Glad to be here.
Well, I mentioned before we got started, I'm so excited to talk to you. I've been looking for an employment attorney to ask questions to.
Well, now you have your chance.
Well, that's great. I get tons of questions in this area. So we'll talk high level today and just maybe give some general tips on some of these topics that come up pretty often. So one of the first places I think that we sometimes encounter problems is with the job interview and the kinds of questions that we're asked. And I know for myself, a job interview I had a few years back, I was asked questions like, are you married? Do you have children? Do you plan to have any children? And that kind of thing. It was kind of uncomfortable. And I'm just curious, what can employers ask us during the job interview and what can't they ask?
Well, the questions you just mentioned really are inappropriate to be asking during an interview because in all likelihood, they're not going to be asking that of their male candidates.
That's true.
And so, to ask women what are their child plans, do they have child care arrangements? Do they plan to get pregnant? Things like that, hiring managers, interviewers should not be asking their interviewees. Mm-hmm. But, certain things that you could ask along those lines where, they're concerned about maybe an employee's availability to work overtime. Mm. Employer can certainly ask, can you work overtime? Let's say you're applying for an accounting office,
mm-hmm.
During tax season, they're going to be working long hours. And you can certainly ask them, during the months of March and April, you'll be here until 8 p.m. at night. Is that okay? Can you do that?
Right.
And certainly, that's a legitimate question to be asking someone.
Yeah, that makes more sense. But that's so much more about the job and can you do the job rather than like if they ask you how many kids you have and then they're making an assumption. So that makes a lot of sense.
Exactly. And that's where, you would hope that an interviewer would keep the questions directly related to, are you going to be able to meet our needs?
Right. So another question that people are issue that people are really worried about is age. They feel like, gosh, the employer might judge me about my age. Is the employer allowed to ask you your age?
No, they should not be asking an applicant's age. Or similar questions like, when did you graduate college? When did you graduate high school? But what they can ask questions are, can you provide proof of age? Many positions, it usually deals with younger interviewers. Mm-hmm. You have to be 18 years old. And
right.
So certainly you would have to provide your proof of age, if you're in a environment that's, construction environment or a manufacturing facility. They want to make sure that that you are, not subject to the child labor laws. And so they can ask for proof of age, but just to come out and ask, someone how old they are, cannot do that.
Okay, that makes a lot of sense. And then also, sometimes the employer will ask you, like, where you're from, like if you're from the U.S. or not from the U.S. Is that okay?
No. And what we're talking about is discrimination on the basis of something.
Okay.
And is the question designed to elicit that type of information? Like, for example, your question earlier about, are you planning to have children? Are you going to get pregnant? Those types of questions that are related to someone's gender. Mm-hmm. That type of question, are you from the U.S., would be intrusive on that person's national origin. Mm-hmm. And so an employer cannot ask, are you from the U.S.? Were you born here? But can ask, can you provide proof that you're eligible to work here? Mm. And so that would be a legitimate question to ask somebody in the interview.
Mm. And if they say, can you provide proof? do you have to explain, yes, I'm a U.S. citizen, or yes, I have a green card? Like, do you have to explain it right then, or can you just say, yes, I have proof?
Right. I would just say, yes, I'm eligible to work in the U.S.
Okay.
And then once, assuming the job is offered and the person is hired, at that point, they will provide the employment verification information, whether it's, just the driver's license and social security card, birth certificate, or whatever immigration documents that they have.
Okay, that makes sense. Are there any other questions that maybe employers might ask that seem kind of, uncomfortable, but in reality that they are allowed to ask?
Well, certainly, one question, or employers often ask questions that tend to elicit whether or not a person has a certain disability or illness or something like that. So you can't ask, a person, have you had any workers' comp claims?
That's interesting. Okay.
Also can't ask, have you had any major illnesses or injuries in the last year? Or ask a question like, how many days were you sick last year?
Oh.
But what the employer can ask is, how many days were you absent last year? Because an absence can cover a myriad of reasons why a person wasn't at work. Could be personal, could be health-related, but at least, that distinction is made that, you can't ask somebody how often they're sick or how many days they missed because they were hurt or injured or sick, but can ask, well, how many days did you miss work last year, period.
Mm-hmm. Gosh, that's interesting. I think of I've encountered so many of these questions. I've even lots of times been asked how tall I am in interviews because I'll wear high heels and I'll be over 6 feet tall, and I'll get a lot of comments about my size, which is also I don't know. It seems strange, but so.
Well, and I understand now. Again, asking about somebody's height, while maybe awkward, isn't necessarily illegal.
Yeah.
My daughter's 6'1". She goes through the very same thing, so I understand.
Yeah. It can be uncomfortable. Sometimes I want to ask the person how much they weigh, but as a response. But anyway, so when we're in these interview situations and they are super uncomfortable, and say we're asked something like, do you have kids? Are you planning to have kids? It is, an illegal question. Do you have any suggestions on how we might approach these?
Well, I think, again, that is a difficult question because the interviewer is there, or interviewee is there because they're interested in this job and want this job and don't want to give an answer that may, keep them from getting it. And so really, it's a gut feel. And, do I just go ahead and answer it honestly? But the advice I would give is, I'm sure during many interviews you're taking notes of what's going on. And so that would be something good to take a note of, that, hey, I was asked this question. Yes, I am planning on having children in the next 5 years. And then I wasn't hired, but they hired this male, applicant. Is that something that might be worth going to see a lawyer about?
It's tough. I mean, I think the thing is, at the end of the day, you are there. Like you said, you want to get the job. And so many hiring decisions are made based on if they like you, if they get along with you. And so when you kind of put them off with an answer, like if you say, I choose not to answer that, it can really create an uncomfortable situation.
Oh, absolutely. Absolutely. And that's why, I would suggest just going with the flow. And answering the question as best you can, keeping your notes in case there is something inappropriate or illegal asked. Again, unless it just gets so awkward, that they're asking questions nobody, in any professional setting should be asking anyone.
Yeah, absolutely. I mean, I think for me, I've always just kind of been graceful about it. And then after I've gotten home, I've reflected on, is this someone I really want to work for? Like,
exactly.
If these are things they want to know about, maybe not. It gives you some good information about them too. Sometimes.
Oh, certainly. That's the question you want to ask yourself. Is this a place that I really want to work?
Mm-hmm. I mean, I think sometimes it's like you dodge a bullet in that moment when you learn about that
better
person.
to find out there than 6 weeks into your employment.
Yeah, absolutely. Well, so after we go through this whole interview process, oftentimes we'll get this phone call from human resources or the hiring manager, and they will give us an offer over the phone. And it's this kind of exciting moment where they're hoping that we'll give an answer right away or whatever. I often advise clients to get that offer in writing. And I was wondering if you could talk a little bit about why is it important to get a job offer in writing?
Well, I think it's important to get that in writing so that both sides know exactly what's expected and what's been agreed to. during the interview process, I'm sure at some point salary has been discussed, certain benefits have been discussed, and you want to make sure that there's a clear understanding of what it is that you're agreeing to. And so it's important that that those be made in writing. Now, any good offer letter will say, while it is somewhat of a contract, many states are what we call employment at will states, which mean a person can be fired, for any reason, with or without notice. Likewise, an employee can quit at any time with or without notice.
Okay.
There are exceptions to that, that we've been going over. You can't let someone go because of their race or their sex or disability, things like that. But in an offer letter, it'll often say that, this is, even though this is an offer letter, you will be employed at will, which means that this isn't a contract, and et cetera. But again, I think it helps to have that clear understanding going in so that, if there are questions later, it's something for the employee to refer back to help them to say, well, this is what you guys said at the very beginning. And so that's always important to have.
No, absolutely. I've actually personally seen a situation where the company forgot one of the financial terms to the agreement, and only because it was in writing were they willing to fulfill on that.
Right, because a lot of things are said in the interview and offer process, and so it's always good to get that offer in writing so we know exactly what is on the table.
So you mentioned a couple of things, but what are the specific things you would expect to see in an offer letter? Like what should we have outlined? Salary?
Well, right. Certainly salary, benefits. Some benefits, there's not much negotiation over. Health insurance has to be provided within 60 days. That is what it is. And certainly depending on the size of the company, more established larger companies like FedEx or AutoZone, they'll have set vacation, paid time off things. But for smaller organizations, they may not have those set, amount of vacation hours or PTO hours. And so you want to make sure that there's a clear understanding of that. And then also, anything else, are they going to provide you with a cell phone or a laptop or something, or reimburse you for that? Other things, other company benefits and perks that would go along with that. What kind of, are you going to be expected to use your own car, if your job travels a lot, and will you be reimbursed properly for that? So those types of things, really the salary, what benefits, reimbursements, and then, of course, when do they expect you to start?
Oh, yeah, that's a really good point, because sometimes we overlook that, and a company can get really specific about when they want you to start, and you really need to know
exactly
in advance. The other thing, too, you mentioned was vacation, and I have found that vacation is fairly negotiable. Like the hiring manager can often toss in an extra week. It's kind of an agreement between you and them. But I think that's another thing. If you do have that special agreement, you would want. Right.
Anytime the hiring manager is saying, well, we don't usually do this, but to get you here, we'll do it. Make sure that is in writing so that there are no questions later on.
Yeah. I once had a hiring manager that announced his departure on my second day. And, if I hadn't gotten things in writing, who knows if the next person would have honored what we had agreed to.
Right.
And you never think when you get hired that the person's quitting on your second day.
Well, right. Or, maybe the hiring manager overstepped his bounds.
Right. That's true.
And, that's not your problem. That's his problem.
That's right. Maybe promised something that was a little more than what he was supposed to.
Exactly.
He or she. Yeah. Well, so another thing that's sometimes included in the offer letter is actually a non-compete. And, sometimes the non-compete says you can't work for competitors, you can't work for clients, or you can't, I've even seen some that say you can't work in a certain industry for a certain length of time. I'm really curious because I get a lot of questions around this issue, and I have a hard time. I don't know what is considered reasonable and what is considered unreasonable, because I feel like we should have an expectation that we can work and make a living. So what is kind of allowed and not allowed with a non-compete?
For an employee to be required to agree to a non-compete, and for a company to be able to enforce one, there has to be some kind of protectable interest on the part of the company that they're trying to protect. Maybe that's customers. Let's say the person is going to be involved in sales and is going to have a lot of customer development, customer contact, and because the company is going to be essentially paying the employee to generate that goodwill, they want to be able to keep that goodwill.
Right.
And so something like that would be reasonable for the company to want to keep you from, generating these clients and getting all this goodwill built up and then going to a competitor and taking all of that with you.
Right.
Even though they've paid you to develop all of that.
Right. So taking the client relationships is what you mean, right?
Exactly. The relationships. Or if an employer has invested a great deal of training in you.
Okay.
It's a field that you're really not familiar with. But they say, well, but you have these other good skills. We can teach you how to do X.
Okay.
And they provide you with, a lot of expensive training to learn, how they work and how they function and information about the job. And then for you to get all of that information and leave and take it with you to a competitor would certainly be somewhat unfair.
What if it was sort of like on-the-job training? It wasn't...
Right. Yeah. Certain generalized training, oftentimes, usually these comes up in the sales context. If the person was just provided information on the company's products and that information is widely available on, you can go on the internet and find these things out, that wouldn't really be something worthy of protection. But if the company has has some patents involved and there are secret processes involved with their products, then that would be protected.
So it seems like something like engineering, for example, would be more likely to have an enforceable non-compete as opposed to something that's like a business-oriented,
exactly.
general...
Some like one individual I had, he worked for a company here, and his job, he had a non-compete, but he really, his job wasn't so much involved in the research and development and manufacturing. He was more of a mechanic. If a production line went and broke down, he would go to, out in the production line and fix it. And as he told me, he says, I couldn't tell you how they make this stuff. All they do is call me up and say, hey, this such and such is not working right. Come try and fix it.
Okay.
And I would go and do that. And even though he had this non-compete, we were able to, talk some sense into the employer because he was wanting to work. He had gotten a better job offer from a competitor.
Yeah.
And, and we were able to work that out because the company realized, well, this guy really doesn't have any information that's going to hurt us.
Yeah. Yeah. Well, that's really good feedback because, I always feel bad for people when they feel like they can't go out and look for another job. They feel tied, so that gives us some guidelines, I think, too.
All right. And usually, you're looking at non-competes or non-solicitations. They understand those are two different animals. A non-compete means you can't go work for another employer within, another competitor at all, whereas a non-solicitation usually says you won't solicit our customers or you won't solicit our employees. The non-solicitations are often more enforceable, and again, whenever there's a dispute over these things, they often get worked out along those lines, which is, as long as you don't try and steal, any of our business, things will be okay.
That makes a lot more sense to me, the client piece, you don't compete for our customers. Like that makes a lot more sense than don't work at the kind of work that you do anymore. Like
right. And that's, the thing, when you do go to court, the one thing that judges and chancellors really are very leery of is keeping somebody from making a living.
Yeah, exactly. So how long, I don't know if maybe there isn't a time frame, but how long do most non-competes or how long do they usually last? Is it like a year, 2 years?
Usually most are a year. You'll see some for 2.
Okay.
Really depends on the industry. If you're talking about somebody who's where the products maybe, there's always coming up with new products really frequently, and so the information that the employee had may be old. Mm-hmm. So, may not need a year-long non-competition or non-solicitation for that. But usually you're looking at a year to 2.
Okay, that's very helpful. Well, so I mentioned before we got started, a lot of the clients that I talk to in particular, or just job seekers in general, there's often something wrong, and that's why they're looking to switch careers. If they were super happy in what they were doing, they might not be looking to move to another industry or completely different role. And sometimes that thing can be they're feeling really upset at work. Maybe their boss is very aggressive. Maybe things are happening and they feel like they're getting sabotaged, like something negative is happening. And, oftentimes I kind of wonder, what is the point at which they should seek advice from legal counsel? Like, at what point should they reach out to someone like you and pick your brain about, is this okay? Like,
Well, if they're feeling that way, I would advise them to reach out to an attorney as soon as possible.
okay.
Because, one, if there is something, attorneys, we can, do two things. We can tell you if what they're doing is illegal, or we can help guide you through the process of, okay, I've got this problem at work. Maybe what they're doing, isn't necessarily illegal, but it is, awkward, uncomfortable, whatever. How can I resolve it? Going to the attorney early on can help figure out what it is the problem. Is this a legal problem, or is this just a personality problem?
Right. No, that's a really good point.
And so, by going to the attorney early on, you can at least have that knowledge going forward. And plus, if it's something that's going on illegally, if someone's being sexually harassed or racially harassed, the attorney can help you, with your documentation and, or maybe just getting it resolved. Let's say it's a job that you do enjoy, but there are a couple people that you don't enjoy working with. And so maybe the attorney can guide you to help get that part of it resolved.
I'm sure you hear about these things all the time.
No, certainly.
I mean, what kinds of things you mentioned, a personality problem versus a legal problem? What would be more on the personality problem side that would be less of a legal problem but just kind of annoying?
A personality problem would be, let's say, you're in a professional office and the office manager is, always kind of looking over your shoulder, always pointing out errors, but not doing it in a very professional way. Instead of saying, well, why is this wrong?
Right.
Pointing at it and saying, just being very direct, blunt. And a lot of people, sometimes that rubs them the wrong way.
Right.
They just think instead of these, they have the perception that the manager is not upset at the problem. The manager is upset with them. And so what the manager may be doing, it just may be a style issue or a personality issue in the way they address it. But now take that into something where the manager is saying, well, you stupid so-and-so, or, get into the name calling. That's a different animal.
Oh, really? Okay. I was wondering about that actually, because there are some managers who equally treat everyone bad.
Well, right. And that's a case that I don't necessarily want to defend on behalf of the company, saying, well, he treats everyone that way, because you don't have a very sympathetic manager.
Yeah. That's tough. Well, not to get too far off into the weeds, but one thing what you just said made me think of was pay. I actually sometimes get questions about, well, I feel like I'm not being paid fairly compared to my peers. I feel like it's really hard to know that, because we don't know how much our peers are making typically.
Well, no, yeah, right. Usually, now, a company can't require its employees to keep their pay silent. You can't.
That's true.
So you can't do that. But in the event that somebody believes that somebody, and usually it comes in with somebody of the opposite sex is making more, or of a different race, or what have you, or younger, maybe. Then, though there are discrimination laws that protect against that. But the employees need to be doing pretty much substantially similar work.
Right. No, that makes sense. Huh. That's interesting. Well, so when we do start to feel that things are going down a bad path and say we're starting to consult with a lawyer, well, let me back up for a second. I think one reason that people sometimes avoid talking to lawyers is they seem scary and they seem expensive. And I'm assuming that if we had a question and we wanted to come in to a lawyer, that most lawyers might have like one meeting with you, either a consultation or, I feel like you're not necessarily engaging in a giant contract with a lawyer just because you came in for a few questions.
No, again, it may be, and I've had these before where somebody just simply, wants to tell me what's going on. and and it's something where I really can't help them with.
Right.
Or at the very least, I can just give them some guidance and say it's not necessarily, this is not what a lawsuit is made of. This is really more personality driven. But here, why don't you try doing these things? And something like that, is not going to be terribly expensive for a person to undertake.
Yeah. I would assume that's just a few hours of time at the most.
Right, at the most.
Yeah. I mean, and I think that's good to keep in mind because it can really help to have that outside perspective.
Oh, absolutely. And plus, many times somebody wants to vent.
Right.
And that happens. They're tired of talking to their spouse about it or whoever, and they're just looking for somebody to listen to them. And sometimes when the attorney listens and gives them some sound advice, then what you paid for that attorney is sometimes a good price for peace of mind.
Absolutely. And I asked this question. I dragged some of my own family members to an attorney to get a will, which is like a different issue. But I remember they were kind of sitting with their arms crossed and they were very upset. They'd never been to an attorney's office and they felt like we were going to be at war with this attorney, And I'm like, this attorney is on your side. Like they're here to be your advocate.
Right. So. Right. We're here to help you. We're here to do this with you. We're not adversaries.
I think it's maybe different than what we picture on TV or, an attorney sometimes seems like such a scary idea when in reality it's
it can
not.
be intimidating. I mean, you come into, especially for people without experience, again, you're dragging relatives who have never needed an attorney, they've never had a will drafted or anything, going to a big office with, nice furniture, may be intimidating. And that's where, we come in to put everybody at ease so that they understand, we're here to help.
Yeah, I think it's almost like going to the doctor in a certain way. Like I was at the doctor in the last year, and this doctor started using all these technical medical terms, and I looked at her because I was starting to get overwhelmed. I said, listen, if we were talking about digital marketing right now, because that's my background, I would totally know what we were talking about, or I could tell you about digital marketing, but I have no idea what you're talking about. Could you just talk to me in a way that I understand? And it's like part of it is just understanding that specialist, whoever it is, they have this special, they have a lot of knowledge in one area, but there's probably other areas where they don't. And you as the consumer, as the job seeker, you probably have some area, like for me, it's marketing. I have friends that are lawyers that ask me for marketing advice. We all have something that we know about. This just happens to be, the specialty of a lawyer.
Well, right, and there's, of course, the lawyers, like doctors, have our own, legal mumbo jumbo.
Right.
And somebody comes to me with a harassment claim and saying, well, the company hasn't done X, Y, and Z. And I could tell them, well, the company has an obligation to prevent and correct any harassing behavior, and make sure. Or I could say, if the company knows about it, they need to put an end to it.
Right. Yeah.
And that's really what it means to them. And, and sometimes it's, well, I complained about it, and then they talked to the person doing it, and it stopped. Well, that's what the company was supposed to do.
Right. No, exactly. Well, so say that we find ourselves in one of these difficult sort of situations. One of the best things I think we can do, you mentioned even like in the interview, taking notes. But one of the best things we can often do is document our situation as we go along. How do you recommend that clients document what's happening? I mean, should they keep a notebook? Should they do it on the computer? Like, what's the
I would
best?
recommend that they do it on a notebook.
Okay.
I would not recommend, if they're taking notes about what's going on at work, don't do that on your work computer. Most workplaces will have some type of company property policy that says the computers, internet, email, etc. belong to us, and we can review these and look through them at any time.
Okay.
And that's perfectly within their rights to do because it's their computer. So if they're going to keep notes, and then they should do that, by a handwritten notebook. And if they want to go home and type them on their own personal computer, that would be okay.
Okay. So it sounds like, what kinds of things should we document? Just the situation that's happening,
Kind of use the 5 W's: who, what, when, where, and why.
Okay, that's great. So we just should write those things down.
Right. Who is involved? When did this happen? Where did it happen? And why is this going on?
Okay.
And what was it that happened?
Yeah, and I assume for you as the lawyer that this kind of information can be really helpful later if it does end up in some kind of a legal situation.
Oh, absolutely, because, time passes, memories fade.
That's true.
And so, by the time you go and see a lawyer about a case, it might be 2 years before you're even giving a deposition on what happened, and then another year if you're in trial. So you're talking, 3 years from a certain event, and, good luck trying to remember exactly what happened unless you had it written down at the time. And it's important that the notes be taken as soon as possible.
Okay.
Because you want to have it fresh in your memory. Don't wait, a week to write down what happened. Do it. If something happened at work that day, go home and write it down, or go to your office and write it down.
Oh, that's a really good advice. So also one thing that we often do when there's an issue is we tend to approach human resources because they're often presented as a really nice group of people that can help us and help make things better. And maybe that's true. But can you help me to understand a little bit about what is HR's role in the company overall?
Well, HR is usually the buffer between the employees and management.
Okay.
And really should try to be the employee's champion. If the employee or the manager is doing something wrong, then it's the role of the human resources manager to stick up for that employee.
Okay.
But if the employee has done something wrong, then they should expect the HR manager to let them know what they've done wrong, let them know what is expected and what type of behavior or performance or whatever it is expected in the future.
That makes sense.
You shouldn't leave a meeting from the HR manager without a clear understanding of where everybody is.
Right. That makes sense. Sometimes I also feel like human resources is there to kind of help minimize legal issues. Do you feel, is that also part of their role?
Oh, absolutely. If an employee comes to a HR manager with a complaint of discrimination or harassment or something going on, the HR manager's obligation to the company is to find out what's going on.
Right.
And to see, if, is there legitimacy to the employee's complaint? Sometimes there is, sometimes there isn't. And sometimes, if it's a true he said, she said, or he said situation, the HR manager can't come to any conclusion on what happened. If there are no witnesses to a situation and it's just one person's word against another, then there's not a lot the HR manager can do except to say, okay, we've looked into it, we can't substantiate it, but understand our company policy prohibits discrimination, it prohibits harassment, but also prohibits retaliation. And so if you believe anyone's retaliating against you for making this complaint, you need to let us know.
Yeah, wow. I know that HR has a really tough job to balance all of that.
Oh, absolutely. They've got to look out for the employees, but at the same time, their boss is, they work for the company.
Well, so speaking of sort of working for the company, one thing that we've seen in Memphis a lot actually over the past, 10 years, it's kind of come in waves, but a number of companies here in particular have offered these optional buyout packages. I know FedEx has done it a few times, and some of the other local big companies have done it too. So they go to the employees and they say, hey, everyone, say of a certain level or above, or they'll say everyone in a certain department, if you would like to leave the company at this time, we would, give you sort of what's known as like a buyout package. If we find ourselves in a situation where we've been offered the option to have a buyout package, what should we know about that?
Well, understand that if you do accept a buyout package, that you are waiving whatever rights you have to sue the company. So it's why it's important to have a lawyer look at it. 2 reasons. One, in case you may have a claim against the company for something related to your employment.
Right.
You want to make sure that that's dealt with. Maybe you don't want to sign the buyout because the value of your claim's more than what they're offering you. But also to make sure that there's nothing odd in the agreement. 9 times out of 10, buyout severance agreements will be pretty standard. But you want to make sure that no one's trying to pull a fast one and inserting something in there that really isn't, shouldn't be there. Somebody putting in a non-solicitation or non-compete at the last minute, something like that. They're trying to be, employers trying to be cute in that regard. But also make sure, that, talk with the lawyer about that. to make sure that you don't have some claim that, you may want to assert. Because once you sign that paper and get that money, then that claim is gone. And with that, many times there are protections for older individuals in that whenever there's a buyout program where it's being offered to a group of employees and it's just not one person, the company is supposed to provide information on those who have been selected for layoff, their positions, and their ages, so that, is this a layoff where they're getting rid of all the employees over 55 or something? And so that's something that the lawyer can look at the data and see if there's a possible claim there. So it's important to have an attorney look at it just to at least say, okay, this is a standard agreement. Understand that, you probably don't have any claim against the company for anything. So, if this is what you want to do, then go ahead and sign it.
And my guess is this would be another situation where it might just be a couple of hours of time with the attorney. And it's definitely a small investment considering how big some of these buyout packages are.
Oh, absolutely. If you're getting, someone's making, six figures and it's a 6-month buyout, you're talking, tens of thousands of dollars.
I think one thing, too, to keep in mind, which I've noticed with a couple of folks I've talked to, is sometimes the buyout has terms that say you could be rehired, and other times it says you can never be rehired by the company if you take it. I've seen some that say after so many years you can be rehired versus you're never eligible.
Right. Usually, it just depends on the circumstances. Let's say if it's just a single employee, the company's come to an employee, they've said basically, for whatever reason, we don't want you here anymore. But, to make this easier, we're going to have a severance package. Many times that severance package will have a no hire provision in there, meaning that we have no obligation to hire you in the future. But if it's a voluntary buyout where, the company's just not doing well and they've got to let some people go, those provisions may be in there that says, hey, you can reapply with us in 3 years and we'll see.
Right,
And so really that's it's up to the company.
I think a lot of times, though, people don't really think about that. They just assume, I'm never going to go back to this company. And I've seen people before who are like, man, I really wanted to go back. And I realized, I can never go back.
Well, right. And again, that's just a decision you have to make. And fortunately, you don't know where you're going to be in 3 or 4 years. But, that's just, do you want, if it's assuming it's voluntary, some of these are involuntary. And it's saying, we're eliminating this department. And so, here's the package.
Yeah, that's definitely a different position, at least emotionally. I mean, I'm thinking more of when they come and say, who wants to volunteer?
Right.
I know that right before I went to graduate school, the company that I worked for was doing these buyouts. And man, every day I came in and I thought, oh, I hope I get it, because I was quitting my job to move to Los Angeles.
Well, right. If it's a situation, where you probably weren't going to be there much longer anyway, you were already looking and they're offering a buyout, hey, let's go.
Right. It's perfect timing. Yeah, absolutely. Well, so I have one last question. And this one I feel like comes up more often than I was kind of expecting. I sometimes will talk to folks who they do have a disability, say it's something like ADHD, and they often have an intention to, reveal that to the employer in the first meeting, because the first interview, because they feel like, I need to be sure they know I have this. I need to be sure they're going to give me accommodations. And I almost get the sense there's an expectation that they should get an extra chance in being hired. But, sometimes I feel a little hesitant about how to advise that person, because my sense would be, and I'll give you my personal opinion, is that when you disclose that information too soon, sometimes the employer, even if it's subconscious, I think they may be judging you, and they may be holding it against you in some way. So I'm wondering, when is the right time to disclose that we have a disability?
Well, I think it would depend on the questions that are being presented.
Right.
A legitimate question would be, are you able to perform these functions of the job?
Right, sure.
And if the person says, well, I can do 1, 2, and 3, but I have ADHD or dyslexia or whatever, so I would have a problem with 4. That would be okay. And I'm with you on that. Somebody just coming out with saying, I've got this in the middle of an interview when you're just saying, hey, tell me about yourself and your work history, it'd kind of be a little off-putting. And And if the goal is to get the job, they can maybe structure things to say, okay, well, no, we're not really worried about their disability. This is why we didn't hire the person. So it can be, a little awkward. We talked about awkward interview questions. That would be certainly an awkward interview response. And so if it pertains to, if the disability would pertain to a question that they're asking as far as their ability to do the job, or ability, question would be, can you work overtime? Oh, well, let me tell you about this. I may have to, I may not be able to work 8 hours a day 10 hours a day every day because of whatever condition. And so that would be, an appropriate time to bring that up.
I totally agree. And I mean, I never want to discourage people from talking about who they are, but I did speak with someone recently who was giving me their elevator pitch for practice, like the tell me about yourself question. And the very first thing the person said was, well, I have ADHD. And then they led into sort of their strengths and what they brought to the table. And I thought, maybe it's just not quite the right time.
Right.
Like maybe there's another time.
Right. The first sentence out of their mouth saying something like that is just just kind of awkward.
And it's distracting.
Right. But now if someone asks you, well, tell me you're talking about your strengths and your weaknesses, and if it's something that you really want to get out there, you can say, well, I believe one of my strengths is, even though I have ADHD, I've been able to overcome that by, doing, certain things.
Absolutely. And I just, I think as progressive as we are, you just never know the biases that person has that you're talking to. I mean, I'm the same way I advise people not to share things like religion or politics. It's like being at a dinner party. Like there's certain things you don't reveal about yourself right up front, and I kind of think this is one of those things, unless it impacts your ability to do the job.
Certainly. Then you definitely want to let the employer know.
Well, this has been really, really, really helpful, Chip. I'm curious. So I know you work with clients here in Memphis. Well, first of all, do you work with individuals?
Yes.
Okay.
I work with both individuals and I work with companies.
Okay. And do you work with people just in Tennessee or in other states as well?
Primarily Tennessee.
Okay.
We seem to get a fair amount of questions out of Mississippi, and we'll talk to them as well.
Okay, great. Well, so if we want to learn more about you and your practice, where should we go?
Well, you can certainly go to our website, evanspetree.com, EVANSPETREE.com, and have a brand new website, and it talks a lot about our firm and how all the legal services we provide. And I'm listed on there under the Labor and Employment Law section, and so that would be the easiest way to get in touch with me.
Oh, that's great. Well, I will put a link to your website in the show notes, and I really appreciate you joining me today. I told you I've really been looking for answers to these questions.
Well, I'm glad you had me, and I enjoyed it as well. Thank you, Angela.
Thank you. Thanks, everyone, for listening, and thanks to those who sent me questions. You can send me your questions to angela@copelandcoaching.com. You can also send me your questions via Twitter. I'm at Copeland Coach, and on Facebook, I'm Copeland Coaching. Don't forget to help me out, subscribe on iTunes, and leave me a review.
Thank you for listening to the Copeland Coaching Podcast today with your host, Angela Copeland. Tune in next time to get more great tips on turning your job search into a slam dunk.